Hello students, welcome to Legacy IAS Academy. So in today's session we are going to discuss about a recent controversy that has made the news headline, that is with regards to the appointment of the new election commissioner by the government of India. So in this particular video we are going to discuss in details how election commissioner of India is appointed, what is the procedure that is followed during the process, and also why Supreme Court has raised the question and what kind of question the Supreme Court has raised in front of central government to justify its stand on the rapid pace appointment of the new election commissioner. So let us try to understand first of all the context of this particular video. So Supreme Court yesterday have questioned the lightning speed at which the Arun Goyal's name was finalized as a new election commissioner. Early before, central government has placed the original file of his appointment before the Constitution bench. Now, Constitution bench is a bench of Supreme Court that is made up of 5 judges, and currently referring to this particular matter, the matter is being, we can say, the bench is basically being headed by Justice K.M. Joseph. And it was Justice K.M. Joseph who has asked central government that central government should try to justify that was there any tearing urgency to appoint the Election Commission of India at such a rapid pace without taking into viewpoint of different stakeholders. And this also is happening at a time just a day after when the Supreme Court is referring to another matter, which is being petition has been filed and the matter is being discussed by the advocate Prasant Bhushan. And there the Supreme Court has also asked government about the mechanism through which a former IAS officer has been appointed as the election commissioner. Now, if we talk about the Election Commission of India, so Election Commission of India derives most of its power and authority from the Article 324 of the Constitution, and later on, the Parliament of India has legislated and brought into an act that is called as ROPA, which is Representation of the People Act 1951. Now, obviously, Election Commission of India is an autonomous as well as a constitutional authority, and the main responsibilities of this body is to administer election process in India and to ensure that free and fair elections take place all across the country. Now, the bodies to which Election Commission of India is responsible for carrying out elections are elections to the Lok Sabha and to the Raj Sabha, that is both the houses of parliament at the central level, as well as the elections to the state legislative assemblies at the state level is also being conducted by the Election Commission of India. At the same time, the offices of president and the vice president of the India, here also we talk about the election procedure that happens under the fair guidance of Election Commission of India. To make sure, you have to understand that as far as the election of panchayat levels or the municipalities level in a state is concerned, these are not under the domain of Election Commission of India. Rather, it is being taken care of by the state election commissions of the individual state themselves. Now the question comes that how election commissioners are appointed. So as far as the appointment procedure is concerned, election commissioners are appointed by the President of India, and they have a tenure which is fixed of 6 years or up to the age of 65 years, whichever is lesser. So that is the first point. Second point is that as far as their freedom, independence is concerned, they enjoy same status and receive similar perks and salaries as the judges of the Supreme Court of India. Now, the next important point is that though the election commissioners are appointed by the President of India, they cannot be removed by the President arbitrarily. Rather, removal of election commissioner has to go through a very arduous process. That is, first of all, a resolution has to be passed to that effect by the both houses of parliament, that is obviously Lok Sabha and Rajya Sabha, with a special majority. And only upon the passage of such recommendation, the President can finally remove the election commissioner of India. Now, the ground of removal is mainly two. One is the proved misbehavior while he is holding the office, or his incapacity, whether it is a mental incapacity or physical incapacity. So, these are the constitutionally mentioned ground on which election commissioners can be removed. So, in this regard, what has the Supreme Court asked from the central government of India? So, the first question that Supreme Court has asked to central government is what was the mechanism of appointment that the central government has followed as far as this particular appointment of recent election commissioner is concerned. Now, to ensure, Supreme Court has clearly stated that the matter referred to it or the question that is asked is not pertaining to the qualification of the election commissioner, because that is not what Supreme Court is interested in. The Supreme Court want to know whether the procedure that has been followed, whether the judgment for the appointment that was basically used, what was the judgment and what was the procedure. So detailed process of that has to be enunciated in front of Supreme Court. Also, Supreme Court has said that whether the manner of appointment can put in a person who can act independently in his post, that is the most important questions, that whether the appointment that has been done by the central government, has it been done taking into consideration or taking care of the main principles that the election commissioner can act in an impartial and independent manner without any pressure of the central government or any governments. So in this regard, what has been the response of the central government? So response has been given by the R. Venkataramani, who is currently the Attorney General of India, and he has said that the principle that enshrines the appointment of election commissioner is based on a time-tested convention, and the appointment takes place after 3 stages. In the first stage, it is the Department of Personnel and Training who prepare the list of all the serving as well as retired officials in the position of secretaries to the Government of India. Once this list is prepared, from out of this list, a panel of name is prepared and then it is submitted for the consideration of the Prime Minister for the appointment of the election commissioners. Once Prime Minister looks at this list, then using his own intelligence, he comes to a name, and this particular name is finally recommended to the President of India. And after the recommendation is submitted, the note also associated with the recommendation is submitted to the president. And after that, president appoint the election commissioner according to the power vested to him according to the Constitution of India. So this same procedure has been followed as far as the appointment of the current election commissioner is concerned. Now, it is not only the matter of appointment or the process that is followed during the process of, during the appointment, but SC also has raised question on whether Election Commission of India is acting as an independent body as it is required to do so as per the Constitution of India. So here Supreme Court has clearly stated that looking at the previous cases of the appointment of election commissioner, government is doing nothing but merely paying the lip service to the independence of the election commissioners. And why government is merely paying the lip service? Supreme Court has said that all the protections that is given to election commissioners in terms of their tenure, in terms of their removal, all this can only make sense if they actually enjoy the office till their complete term. But if you look at the past instances, very few election commissioners have been able to hold the office and completed their tenure. So all the guarantee or the protections given to them by the Constitution of India basically fails in that. And thus, Supreme Court has said that there is a need for an independent, neutral mechanism to appoint election commissioner, which should be outside the control of the government. So coming to again the second point that the Supreme Court has made, that whether really election commissioners are not able to complete the term. So let us look at this from this particular data that we have been we have taken from the election commissioner website. So what we can see, if you compare in the earlier times just after the independence of India, for example, the first election commissioner of India, Mr. Sukumar Singh, he has a complete tenure of 3,193 days. After that, the second election commissioner enjoyed a tenure of 3,204 days. After that, what we can see that overall tenure was somewhere between 1,000 days, 1,500 days, or we can say somewhere between 1,000 to 2,000 days. However, after 2004, the government has observed that what we see, government is appointing those civil servant as election commissioner who are enjoying very less days as their tenure. For example, if you look at even last 4 election commissioners, they have enjoyed tenure somewhere ranging from 200 all the way up to 800 days, which are very less. And for any reform to occur, the election commissioner tenure has to be sufficiently longer so that any reform can take place, important reforms can take place to the Election Commission of India. And in this regard, Supreme Court also have stated that phenomena like T.N. Seshan, who was considered as the most revolutionary and transformative election commissioner of India, happens sometimes or rarely, and that is why we have to ensure that the prescribed tenure of election commissioners are fulfilled. So that is another question that has been raised in front of the central government. Now, what the reason is that the Supreme Court of India has been forced to raise question on the independence of Election Commission of India. So this we can understand from the few past incidences. For example, a report that has been submitted by Citizens Commission on Election, it has clearly stated that many times we have seen several instances where Election Commission has enacted or has not taken appropriate action, especially while conducting the 2019 general election. And in this regard, even the Chief Election Commissioner at that time, Ashok Lavasa, he wanted to take action against the then Prime Minister of India, Mr. Narendra Modi, but he was hounded by the government, and thus he was forced to not take any action in the context of violation of the Model Code of Conduct. Similarly, we have several writ petitions. 3 writ petitions have been filed in the recent years, where the petitioners have asked the Supreme Court to declare that the current practice of appointment of election commissioners by the central government is violating of the basic structure of the constitution. And how it is violating of the basic structure of constitution? Because it violates Article 14, Article 324, Clause 2, as well as the democratic principles that is enshrined in the Constitution of India. Recently, also in the Anup Baranwal versus Union of India, the point has been raised that demand for that a collegium system should be established that should have representation from the government as well as from the judiciary to ensure that the process followed during the appointment of election commissioner are impartial and not fully controlled by the government itself. So what we can say should be way forward as far as the appointment and independence of election commissioners is concerned. So we can look back to the previous reports that has been submitted by different committees. For example, the earliest report we can look at is the Justice Tarkunde Committee report, which was submitted in the year 1975. Justice Tarkunde Committee has clearly stated that instead of solely depending on the Prime Minister for the appointment of election commissioners, rather we should comprise a committee, and this committee should be composed of Prime Minister of India, opposition leader of Lok Sabha, as well as Chief Justice of India. The similar recommendation has been upheld by the later committees as well, such as Dinesh Goswami Committee in year 1990, as well as Law Commission of India in year 2015. Not only that, even if you look at the recommendation of the second Administrative Reform Commission, it has clearly stated that the principles and the recommendation of Justice Tarkunde Committee should be upheld. Rather, it has made an addition where it has said that apart from the PM, the opposition leader of Lok Sabha, and the Chief Justice of India, the Law Minister of India as well as the Deputy Chairman Raj Sabha should also be included in the collegium, and thus we should have a 5-member collegium that should decide upon the appointment of the matters related to the appointment of the election commissioners of India. Similar kind of observation has been made by the Honorable Supreme Court as well, wherein the matter referring to Roger Matthew versus South Indian Bank Limited, Supreme Court has observed that as far as the election commissioner, its roles, its independence is concerned, it is not only responsible for conducting free and fair elections, but also it has quasi-judicial functions. And since it has a quasi-judicial function, because it also acts as a quasi-judicial body when it is referring to matters where 2 different political parties are at conflict with each other, registration of political parties and their symbols are concerned, these all are taken care of the election commission. And that is why the full control of government is not good. Rather, the full control of government over the appointment procedure of election commissioner renders the whole process and institution vulnerable to manipulation to serve the interest of the government itself. And it is on this ground there is a need for an independent body which should not be totally under the control of government to appoint the election commissioner. Thus, after discussing about all these things, what we can say in conclusion, that as far as the Election Commission of India is concerned, obviously it is one of the most important body which can uphold the democratic principles enshrined in our constitution, and thus Parliament should preempt any judicial structures or any judicial decisions and should go ahead, formulate a law and establish a multi-institutional bipartisan collegium to select election commissioners of India. This will also serve as a very important step in ensuring the separation of powers between the executive, legislature and the judiciary is maintained. And this is very, very important because the separation of power is the gold standard for governments across the world, that how successful or how democratic a governmental structure is. And thus existing veil over the appointment procedure of election commissioners, it potentially undermines the very structure on which our democratic aspirations rest. And that is why it is the high time we should heed to the recommendations given by the earlier committees and should introduce these recommendations in the ongoing or in the next appointment procedure. So that is all about this particular video. I hope you understood about the controversy surrounding the appointment of election commissioners. If you like the video, please hit the like button, share it with your aspirants, as well as subscribe to our channel for more helpful content. Thank you very much.